There you see Prosecutor John Champion delivering his closing arguments in the Quentin Tellis case out of Mississippi from 2017. We're about to conclude showing you that whole case. We've replayed the whole case for you because we wanted you to be prepared when we believe in 2018 Quentin Tellis will be retried in connection with the death of 19-year-old Jessica Chambers. We'll talk about that in a little bit. Right now we want to focus on a new case that's coming down the pipeline. We believe there's going to be a live feed any moment now. This is the case out of California, the case of Jason Riley King, that former Marine who was accused of driving the wrong way while drunk. He caused a head-on freeway collision that killed two UCSD medical students, Ann Lee Baldock, who was 24 years old, and Madison Elizabeth Cornwell, who was 23 years old, and injuring three others. There's a lot to talk about here, including the charges. He faces 2 counts of murder in the first degree, 2 counts of gross vehicular manslaughter while impaired, DUI resulting in great bodily injury, driving with a blood alcohol content of 0.08, 0.14 causing injury. Really, really interesting stuff, including the fact that he rejected 2 prior plea deals. So as we wait for the live feed, we have a lot of questions about this new case, our brand new case here on the Law and Crime Network. I'm joined right now by criminal defense attorney and my good friend Ken Belkin. Ken, good to see you here in 2018.
Good to see you, Jesse. Happy New Year.
Happy New Year. You like the new set?
I love it. It's great.
It suits you well. It suits you well.
Does it match my suit?
It does. Let's talk about this case. I have a lot of questions. I'm glad you're in studio to talk about it. First question I have is, why is he charged with first-degree murder in a car accident?
Well, look, we all know first-degree murder. It's got that common conception of it that it requires premeditation, deliberation. You remember law school.
I do. I sat right next to you.
Professor Turkheimer, you know, premeditation. There's got to be planning. There's got to be a little bit more than planning, even real deliberation. In California, they require what's called malice aforethought. You know, the intent to kill, that you intended to end this person's life.
Sure.
Now, in California, they also have the felony murder rule. And if you commit a felony that results in the death of someone else, you can be charged under first-degree murder for that death. And in this case, you've got the felony drunk driving, you know, driving under the influence that results in great bodily harm. It's a felony.
Now, wait a second, Ken. If that was the case where everybody dies as a result of car accidents, do you just see first-degree murder charges all over the place?
It's not just, look, there is the vehicular manslaughter, but the drunk driving resulting in great bodily harm, that's a felony. Typically, drunk driving, you know, with a .14 wouldn't result in a felony charge. It would be misdemeanor drunk driving in most jurisdictions. But the way you bump up to a felony drunk driving is when there's an aggravating factor. Aggravating factor could be, you know, property damage, a lot of property damage usually. It could be serious bodily injury. Could be death, as we have in this case.
So what about the fact that this, from all accounts that we know so far, we believe there were multiple people, his friends, staff members at the bar that he was at earlier in the night, who told him not to drive, and he did it anyway. Is that a factor?
I mean, I don't know that that would really weigh in the factor the way the statutes are written, but it certainly does not help his case. Because now you've got witnesses that saw him intoxicated, let alone they've already got the evidence of his blood alcohol content. But these extra witnesses, it's really going to bolster the prosecution's case. You're really going to see that, like, look, this guy had the opportunity to take the good advice of his friends and the staff members at this bar to not drive, and he shirked it. He said, to hell with it, I'm driving anyway.
So I'm confused how he defends this kind of behavior, this kind of case, because he rejected 2 plea deals, Ken. We talked about this. He rejected a plea deal to second-degree murder and DUI. That would have been a sentence of 15 years to life plus 8 years. And he also rejected a prosecution's offer for gross vehicular manslaughter while intoxicated, DUI, and attempted murder. And from what we've seen, that was a sentence of more than 25 years in prison. But the idea that these lesser charges and now he faces 30 years to life plus 14 years if convicted, why would he reject it? What is his defense going to be here?
Well, look, if he's convicted on the top count, there's only 3 possible sentences for first-degree murder in California. There's 25 to life, life without parole, and death. I don't believe they're going for the death penalty in this case. I don't believe it's warranted in this case. I think the likely outcome is he's probably going to get 25 to life. They're going to get him on that top count. It's going to be very hard not to. They've got very strong evidence. They've got the chemical test that indicated his blood alcohol content was almost double the legal limit in that jurisdiction, where it's .08, he's .14, just shy of double. You've got multiple people from the bar told him not to drive, and you've got the very young victims that were med students. They're very sympathetic victims, and a great outcry from the community and the families.
So what can we expect from a defense today? We're expecting why is this even going to trial then?
I think they're probably going to try and use some defense. He was a Marine. He served bravely in our military, which he should be commended for. And, maybe that's a sympathetic factor that should factor into his sentence. But it doesn't really weigh on the facts. I think they're really going to try and pull the sympathy card. But there really is not a great defense here. This is not...
It's not like he's saying he didn't do it.
Yeah, I mean, there's no dispute about that.
I'm not saying that he wasn't drunk, right?
Yeah.
I mean, but is the idea, okay, is it going to be one of those cases where we'll attack all the ways the evidence was collected? All those procedural aspects and really try to break the case? Because again, at the end of the day, all they have to show is reasonable doubt. But what does that mean in this kind of case?
I mean, at this point, it's at trial. So the evidentiary issues should have largely been settled pre-trial and in pre-trial hearings. Look, they're going to get that chemical test in that indicated his blood alcohol content level was almost double. They're going to get it in. Now, he could have refused to take the test at the time, but he didn't. Had he refused, he would have had a much stronger case, because the only evidence of intoxication would be eyewitness testimony from the bar and potentially the observation of the arresting officer or responding officers.
Yeah.
Where they could say, there was a smell of alcohol, he had bloodshot eyes, his gait was not straight, but all those things don't necessarily prove intoxication. The fact that he took the chemical test, it is the cornerstone of the prosecution's case.
And let's not forget, it wasn't that this just was a car accident. He was driving on the towards traffic. So it's not like, I have to assume if there was a car accident or there was a car collision and people are driving on the same part of the road and you swerve, that might be a little bit of a different kind of scenario where you are 100% in the wrong. You're driving towards, it's a head-on collision.
Yeah,
on a freeway.
I don't see any scenario where he doesn't get convicted of at least one count of first-degree murder, if not both. I see him going down for all the charges, quite frankly, and I would be very surprised if that's not the case.
I mean, I'm shocked he didn't take at least the deal that would have gotten him a much lesser charge. I'm shocked that I didn't see it, and he had 2 opportunities to take it.
Well, look,
you would have counseled him differently, wouldn't you?
Well, it depends. Look, he's looking at 25 years anyway.
But 15 years if he took the first offer, pleading guilty to second-degree murder and DUI.
Yeah, I would have definitely counseled him to take that offer.
Yeah.
Look, sometimes, you don't get the offer you want from the prosecution, and you have to take it to trial. Sometimes you have to take it right to the footsteps, the doorsteps of the trial to get a good offer. But this is not one of those cases. They made an offer that was 10 years off of what he could get at trial.
Yeah, there's been talk, you mentioned it before, if the prosecution really show that disregard for human life, I think that's really going to be key here. And we talked about the idea that it seemed people warned him about jumping in that car. We talked about it in the break. Isn't there some sort of new law now in California in response to this case? Yeah,
there's a recent law that was voted in that takes effect this year that requires that anyone who serves alcohol in a licensed premises that's licensed to serve alcohol, they have to undergo a training to recognize signs of intoxication. You're not supposed to serve someone who is intoxicated. People don't always know who's intoxicated.
I think that's a good idea because, you can work in a bar, but how long? Maybe there's people who are new to a bar, or maybe how do you know what the signs are? Isn't it super subjective? Everybody, he appeared intoxicated. Well, what told you that?
Yeah.
You hear these people on the stand.
And some people don't show it at all. I have some friends when they get drunk, some that we went to law school with, that, they really act a fool and they get belligerent after they've had a couple of drinks, very slurred speech, not so steady on their feet. Whereas, I could drink all night, and you would never.
That's a separate conversation. That's a separate conversation for a
But I don't drink these days.
But isn't that kind of like the dram shop laws a little bit, holding bars
trying to hold them
and bartenders responsible? A little bit. How much are they responsible for? I mean, this is a horrific incident.
Yeah,
these
totally
2 young people that were just killed.
Very promising lives.
They're medical students, and 3 others were injured. It's a senseless act here. It didn't have to happen.
Yeah.
So how much do you hold the bars and the bartenders and establishments. We talked about a case a few weeks ago about a fraternity that, you know, gave alcohol to somebody and died. I mean, how much do you have to hold the people that are the purveyors of alcohol in these kinds of scenarios?
Well, that's a question that we're grappling with in our society, and the lawmakers are coming to new conclusions on that. I stand by the old creed that someone's criminal actions supersedes any liability of someone who did not commit a criminal action. Meaning, look, yeah, they tried to prevent him from driving, but at the end of the day, it was his decision, and he put himself behind that wheel, and he decided to drive, which was a criminal action. And I believe that the old premise that would supersede any liability on behalf of the purveyor of the alcohol.
Yeah. Ken, you make a really good point. I'm glad we have you here today to talk about what's happening in this case. But I know that I'm going to be signing off in a minute, but I know you have a special segment coming on with Heather Hansen about Google. You excited to talk about that one?
I am. James Damore. It's an intellectual obsession of mine, this guy.
Well, that's why we like having you on. Your colorful commentary is just that. It's colorful. So you're not going to want to miss it. Everybody stand by. Ken is going to talk with Heather Hansen about the latest development in Google. We are waiting for a live feed right now out of that California courtroom to talk about this case, this really horrific case. So as soon as we do have a live feed, we will make sure to go to it. In the meantime, as promised, we are concluding showing you the Quentin Tellis replays. And right now, we are going to show you the conclusion of that case because, again, the reason we've showed you this all this past week is because we anticipate in 2018 that Mr. Tellis will be retried in connection with the death of 19-year-old Jessica Chambers. So in conclusion, here is the end of that case.